For those of you who don't know me, my name is Martin Sloan. I'm one of the partners here at Brodies, and I'll be presenting this morning alongside Grant Campbell, another one of the partners in our data protection and information law team. Before I start, I should just say you'll notice we have cameras at the back today. We are live streaming this, but we will be cutting the broadcast when we get to the Q&A, so please don't feel afraid to ask any difficult questions when we get to that point. We won't be recording that. So, what we're going to do today is, we called it Spring 2018 Update. As I think those of you who are regular attendees will know, we do this update twice a year. I know we're now into June, but we thought that it would make sense possibly to wait until after the 25th of May to do this update. And what 6 months it's been since we last spoke. First of all, back at the start of December, we had Morrison's Supermarket, who lost a big court case in terms of liability to their employees for a insider data leak, and I'll talk a bit more about that later on. We then had our Secretary of State for Culture, who launched his own app, launched it with a privacy notice that made absolutely no sense at all, wasn't GDPR compliant. Not great leadership perhaps there, in terms of showing how we should be complying with the new laws. We then had Cambridge Analytica, of course, and Facebook in March. Then the first right to be forgotten case in the mainland UK involving Google and a couple of individuals who wanted some search listings taken down about them. We then had a lot of GDPR emails coming out asking for your consent. A lot of those were probably unnecessary. I'll talk a bit more about that later on. Then something called the General Data Protection Regulation. No, never heard of it. And then finally, the day that came into force, Max Schrems, our old privacy activist friend, brought complaints against Facebook and Google and a couple of other social media networks in relation to what he referred to as forced consent, and whether actually all those privacy notices you had to go through on those apps were actually compliant with GDPR. So this morning we'll take you through just a refresh of the new regulatory framework that we've got. Grant will take you through that bit, and then talk about what we think you should be doing in terms of your focus for moving on from getting ready for GDPR in terms of your accountability within your organisations. What are the key priorities? Dealing with data subject requests, I'm sure a lot of you will have had requests, perhaps receiving them for the first time. What should you be doing with those? How can you deal with them more efficiently? And then I'll look at some of the common issues we're seeing both in the run-up to GDPR coming into force and also in terms of the first 2 weeks, what challenges organisations are facing. Talk a little bit about ePrivacy and where we are in reforms in ePrivacy laws. And then we'll go through some recent cases and some Information Commission enforcement action, and also look at our usual update in terms of what the current trends are for data security incidents that are affecting organisations. So I will hand over to Grant, who will take you through the new framework.
Thank you, Martin. Good morning, everyone. GDPR has grabbed all the headlines, so everybody is familiar with GDPR, but there's more to the regulatory framework than just GDPR. Rather unheralded, there was a Data Protection Act 2018, which received royal assent on the 23rd of May, which is definitely cutting it very, very fine. I'll hold up just for visual effect. This is GDPR and the Data Protection Act combined. So the Data Protection Act itself runs to 215 sections, 20 schedules, and 339 pages. In order to understand how GDPR operates in the UK, you need to understand the Data Protection Act 2018. It's not just a case of understanding GDPR. So when we're talking about GDPR in the UK, we are talking about GDPR as supplemented by the Data Protection Act 2018. Our old friend, the Data Protection Act 1998, is no more. It is gone. Why is this important? Why is the 2018 Act important? Well, it is important because it does a number of things. So in relation to special category personal data, so information about health, about trade union membership, political opinions, all of this kind of stuff, there are conditions in the Schedule 1 to the Act that explain and supplement the provisions of GDPR to allow processing of that special category data. So when you're thinking about the bases on which you can process special category data, it's not just a case of looking at the text of GDPR, you need to look at the text of the 2018 Act. Schedules 2, 3 and 4 of the 2018 Act contain various exemptions and derogations. This is all permitted by GDPR. Now, one of the things I think people don't appreciate, everybody thinks GDPR harmonises data protection law right across Europe, and to a certain extent it does, but GDPR itself envisaged that member states were free to legislate within certain areas. And the 2018 Act is the UK's legislative response to that, but each member state has legislated in different ways. So actually there is harmonisation at one level, but within GDPR, within the construct, there was always the flexibility for member states to do some legislation themselves. So if you operate in multiple jurisdictions, it is important to bear that in mind. The exemption derogation, one of the ones that's particularly important is when you're looking at subject access requests, which I will talk about a little later. The exemptions that we used to have in Schedule 7 of the Data Protection Act, 1998, are found in the relevant schedule of the 2018 Act. The other reason that the 2018 Act is important is it contains the new enforcement and audit powers for the ICO. And these are quite important. The ICO is becoming a much more scary regulator than it was under the 1998 Act. There are new criminal offences in the 2018 Act. So destroying or altering personal data that an individual is entitled to see after a subject rights request has come in, so a subject access request typically, is a criminal offence. Reconstructing previously anonymised personal data without the consent of the controller is also a criminal offence. There are various exceptions, but broadly it is a criminal offence. Knowingly or recklessly disclosing or obtaining personal data without the consent of the controller is also a criminal offence. And the same provisions that were in the 1998 Act about senior managers who connive in these activities also being guilty of offence are still there too. The other new thing is we have a new EU regulatory body. So the Article 29 Working Party has gone and has been replaced by the European Data Protection Board. Now that Data Protection Board has a number of purposes. Firstly, it is there to try and ensure that there is consistency of regulatory interpretation of GDPR across all member states. It's also there to ensure that if there are any disagreements between national supervisory authorities, they are sorted. And importantly, it approves EU-wide codes and certifications. Now, one of its first acts, the board, was to actually adopt all the Article 29 Working Party guidance. So if you've been working to that guidance in your preparation for GDPR, the good news is the board has adopted it all, it's still all valid. And it has approved new guidance on international transfers. One of the things that we would say when you're looking at the guidance that has been issued by the Article 29 Working Party and now the board, is it isn't always clear to us in their guidance that they're making a distinction between what the law actually requires and what they as regulators would like to see. So there is, we feel, an element of gold plating to some of the guidance that they issue. And I think it's just important to bear that in mind when you're looking at the regulatory guidance. Ultimately, decisions as to whether or not someone is complying with the law will be matters for the courts. Regulatory review is important, but it is not the final determinant. We still have the Information Commissioner's Office, so still the UK Supervisory Authority, but it will be interesting to see, particularly given this requirement for consistency through the European Data Protection Board mechanism, whether the ICO's approach, which has been very pragmatic over the years, will change, whether it will be forced to change as a result of having to toe the line with the majority of other regulators within the EU. The UK-specific guidance that the ICO has issued, I think it is clear has been constrained by the need to only go at the same pace as the guidance has been issued at a European level. It's clear the ICO didn't want to go out with guidance that was out of step with its other regulators. The ICO will have new enforcement powers under the 2018 Act. So there are new powers to conduct dawn raids, there are powers to suspend processing, as well as the powers to fine, which were much heralded under GDPR. There are also new offences in Schedule 15 to the 2018 Act for obstructing the ICO in exercising its powers, and also failing to comply with an information notice or making false statements to the Commissioner. So again, there are new criminal offences in relation to the ICO's powers. And the ICO is under a statutory obligation to issue certain codes of practice, and I'll talk about those when we look forward to what we expect to see in the next few months. So when it comes to the regulatory guidance, there has been a stream, I was going to say a steady stream, but there's been a stream of stuff from both the UK, the Information Commissioner's Office, and the Article 29 Working Party. The stuff that I think is probably most important for people to be aware of is the guidance on consent, the guidance on transparency, and in transparency that's been particularly important in terms of the regulatory expectation for privacy notices. There's been guidance in relation to how to handle personal data breaches, automated decision making, and also, obviously, the powers to fine. We set out the links to where you can find that guidance. In the case of the European Data Protection Board, given it is a very, very new being, only came into force on the 25th of May, it can be quite difficult to find it if you just Google it. So the link there should help you find the page for the European Data Protection Board much more readily than we could. So, GDPR, the end of the beginning, or as I like to call it, just phase 2. So, I think it's fair to say most GDPR projects are still ongoing to some extent, and probably your organisation is going to fall into one of 3 baskets. So, you may be one of the lucky ones, and we have some clients who are the lucky ones, where the project is largely complete. They're basically dotting I's and crossing T's. I think a lot of organisations are in the second category, which is we have an updated privacy notice on our website. We look GDPR compliant, but actually we are still doing a hell of a lot of motoring in the background because we've got a lot of actions that we are still in the process of doing. And then there is, I think, a sizable number of organisations who are still just at the beginning. It's interesting, you know, if you go onto people's websites to see how many organisations don't yet have GDPR compliant privacy notices. But wherever you are in this new era, I think one thing is absolutely true. We're not going backwards. Data protection, this is not like Y2K. You know, everyone, I think, on Y2K thought on the 2nd of January, oh God, what a damp squib this has been. But actually, the 26th of May, nothing much had changed, but actually, it's an ongoing journey, and you will only find out how good you are in due course in terms of your preparations. So compliance is an ongoing exercise, and it will require continual review, just like any other compliance exercise. If you haven't done anything yet, and I suspect there are very few in this audience who have done nothing yet, simply because you're all here, but I think it was true to say 25th of May was not a date to panic about. It was a very important date on a compliance journey, but actually the ICO was unlikely to be knocking on your door on the 25th or 26th of May, unless probably one of 2 things had happened. You had a data breach. Oh, Dixon's car phone. Bet you were wishing it didn't happen. Or you've got a trail of complaints. So I think unless you have a data security breach, or you're having a whole load of people who are very unhappy with the way you're handling data, it's unlikely you will be on the ICO's watch list at least immediately. But organisations who do nothing are taking a very big risk, because if you do have a data breach and the ICO does get involved and it is staringly obvious that you have done nothing, then I think the ICO will view that very, very badly. I think the ICO's attitude at the moment is we understand that people are still on a journey and we're willing to give people a bit of latitude. But if you've done absolutely nothing, you are taking a big risk. And we've seen there's market pressure. I mean, most organisations will have come across somebody who's sending a questionnaire saying, how are you handling data? Do you have a GDPR project? And if you're in a supply chain, that cascades its way down the supply chain. And I think organisations who don't take GDPR seriously may find that their opportunities to get on tenders, their opportunities to pre-qualify for work may dry up. because I think there will be an expectation that everybody will have a good story to tell if they want to win work. And there's also a massive reputational risk. If you don't take this seriously and bad things happen and the regulator gets involved, then reputationally it will be very difficult. And you know, we see that with Dixon's car phone. Now I don't know what the outcome of that will be, but everybody's talking about it. And you know, we saw with TalkTalk back in 2015, massive reputational damage, massive loss of customers, and a much bigger bill than the headline fine actually was. So if you are in the process of starting, if you go to our hub, you will find a lot of information. But actually, we've tried to summarise that as to what we think organisations should be doing. And for those of you who are on a journey, that list may still be useful. So it is all about accountability. GDPR is all about accountability. So we've got a ready checklist. I'm not going to run through all of them, but a ready checklist of the key things that we think you should be having by way of policies and procedures. And I'm a big believer that a lot of the practical GDPR compliance is not just about policy and governance, it's about day-to-day process. It's about ensuring that people at the coalface, people who are doing their day-to-day jobs, are thinking privacy. And it's about ensuring that there are processes for what people do, and where there are processes, people follow them. And where there are processes, have they been critically appraised to make sure that they still are fit for purpose? Because in a lot of organisations, how people go about things is just simply the way they were shown. And the way they were shown may have been handed down from generation of folk to generation, when actually these processes were actually hatched. There was no real focus on data governance at all. So making sure that organisations have process in place is actually a very, very key way to ensuring that you comply. And from that, I think staff training and internal awareness is hugely important, and I want to say a few words about that. When it comes to staff training and internal awareness, it is not a one-off exercise. So I'm a firm believer that you have to build a programme of education, and that's training sessions and regular training sessions, but it's about increasing awareness. So things like posters, you know, you may think they're gimmicky, mugs and all this kind of stuff, just to try and make sure that people in the organisation get gentle, constant reminders that this sort of stuff is important. And I think it's also important when you start out on a training programme not to overload people. So start with the absolute basics, get everybody to understand the basics, and then you can then move on into more specific stuff. But it should all be appropriate to people's jobs. Not everyone in the organisation needs to be a GDPR expert. What they need to know is what they need to know to do their job properly. So what I think most staff need to understand is what personal data is as a given, but actually how they should handle that personal data, what they should be collecting, what they should be recording, and what they are using it for. What do they need to do to keep the data secure? What do they need to do to make your data retention policy work? So that means probably filing stuff in the right place so that when you apply your data retention policy, it actually works. They need to be able, and I think everyone in the organisation needs to be able to spot a data subject request. Not because they all need to be able to handle it, but they need to then know where to put it and who to give it to. And similarly, data breaches, we all hope that they won't happen, but I think the reality for almost every organisation is if you process any sizable quantity of personal data, you have to prepare for the eventuality that something will go wrong. So everyone in the organisation needs to understand what a personal data breach might look like and what to do with it. And that generally involves almost immediate action given the 72-hour deadline that GDPR imposes where there is a reportable breach. But I think you also need to think about the tools that you would give to your staff. So if you're expecting them to homework, you need to think about how that homeworking can be done in a way that is consistent with the requirements of data protection. And I'm a firm believer that when it comes to technology, you can help to mitigate the risks. So one of the topics I'll talk about a little later is email. So can you do things like, for example, deploying technology that helps with checking of email addresses, because actually sending emails to the wrong people is one of the most common ways that you can lose data. So on data subject requests, just on this slide, what I've tried to do here is just come up with some practical tips. Again, I won't go through this in great detail. A lot of it is obvious, but it is important. You need to make sure that all your staff can spot a subject request. You try and direct them to a specific person or a specific email address, whatever, but you have to recognize that you can't force that. So you can try to direct people to it, but you can't force it. So everybody needs a general awareness. Having checklists, trackers so that dates aren't missed, template letters for responding, remembering that actually when you're dealing with subject requests, you can't charge, and even if you could charge under the old regime, £10 didn't come close to washing its face in terms of the cost. So what you're trying to do is to make your response to requests as slick and as painless and as cheap as possible in order to ensure that you actually do what you need to do. Where you can try and get the individual to refine the request so that it's clear what it is you're looking for, and then understand when you can charge a fee, because under GDPR you can charge fees, but only in exceptional circumstances. Consider, and what I've said to a number of clients is consider whether you can use technology perhaps to automate a process, but actually for other than perhaps subject access, where we're pretty confident that there are going to be lots of requests. In other areas, for example, like data portability, suck it and see, because actually you may find that you only get a couple of requests. If the right is potentially applicable, you may only get 1 or 2 requests, and you can deal with those manually. But if it turns out that you're going to actually get a lot of requests, then you may need to think about whether or not technology can assist. And if you don't want to disclose the information, you need to be clear what exemptions you can rely on, and make sure that you are using your data retention policy and that you're actually erasing data that you don't need to keep, because actually data minimization is one of the most effective ways to comply. And understand also, make sure that staff actually understand what they should record and what they shouldn't record. A lot of the problems come because people record stuff that they actually really shouldn't have recorded in the first place. So some simple measures can really help to ease some of the pains that will come from these subject requests. I'll hand over to Martin with some hot topics for the first couple of weeks.
Thank you. Okay, so what we're going to do now is look at 2 things. Firstly, some things we've seen in the first couple of weeks of GDPR being enforced, and then secondly, just look at some of the things that were causing clients a bit of a headache in the run-up to GDPR coming into force. So Grant's spoken a bit about data subject requests, and I think it's fair to say that GDPR has had a lot of coverage. People are far more aware of their rights under GDPR, and that has meant that more people are exercising those rights. They're testing it out. They're finding out what they can do. Now, a lot of these rights existed under the old law, but people are just far more aware of them, far more likely to exercise them and find out what organisations hold. So certainly from the clients that we've been working with, we had people who received data subject requests within days of GDPR coming into force. And some of those organisations received data subject requests for the first time. They'd either never received one before, they may have received 1 or 2 over the years, but suddenly they were getting a number of them coming in. So the tips that Grant went through in terms of how you deal with those are really helpful for working out how you deal with that. We've also had a few clients who have had data breach incidents, so they've had to work out whether or not those breaches are reportable, because remember, not every breach is reportable to the Information Commission. Not every breach will be something you have to notify to the individuals involved as well. But you've got to go through the process, and if you're not going to report, work out why that is and why you're justifying that. So again, data breaches happen every day. Under the new regime, you're now to pay a lot more attention to those and how you handle them. And in any event, record them. Even if you don't have to notify them to the Information Commissioner, you still need to actually record them on your internal register. I mentioned at the start Max Schrems, the privacy activist who was behind the challenge to Safe Harbour, for those of you that ever exported personal data to the US. His privacy activist organisation filed complaints with Facebook and Google and WhatsApp and Instagram on the 25th of May. And this was all around, as I say, the forced consent issues. So for those of you that use those apps, you'll have gone through the new privacy notice that said, this is what we do, and then it said, and here's things that we do where we need your consent, and you say, I don't want to give my consent, or my option says, well, here's how you delete your account. So his point is that there's no real choice for the individuals in terms of what they can do. If you want to use the service, you have to give your consent. And that, there's a bit of a tension under GDPR as to whether that is lawful or not. And that, I think, would be interesting to watch, because that has repercussions for a lot of organisations in terms of how we rely upon consent, where it is something that is intrinsic to how, say, a service is funded or how it operates. Particularly the advertising industry are watching that very closely. Well, let's settle down. I think certainly there'll be a peak in terms of requests that we're getting, and then people will perhaps move on to other things. But as Grant has said, we're in the new era now, so people are far more aware of their rights and far more likely to exercise them. So what other things have been causing people challenges? Well, firstly, on unlawful processing. So one of the things that organisations have gone through in the run-up to GDPR is looking at what they do with personal data and what the legal basis is for that, and actually trying to work out, how are we justifying what we're doing here? I think historically a lot of people have done certain things with personal data but not necessarily thought about what their legal basis is for that. And there are particular issues around criminal records checks. So if you carry out blanket criminal records checks on new staff, or perhaps you're a university and you do it on course admissions or something like that, then actually trying to find a legal basis for that under data protection law is quite challenging. If you're in a regulated industry, then there are clear routes you can rely upon, but blanket checks, it seems much harder to justify. And the government last August had promised that they would introduce specific measures to allow all organisations to carry out proportionate checks, but that wasn't in the Data Protection Act or Data Protection Bill when it was published, and didn't go in despite this point being raised in evidence to Parliament. So if you use criminal records checks, just think about what your legal basis is for that and whether those are actually lawful. Similarly, biometrics. So under GDPR, using biometric information to identify an individual is special category personal data. So you need to be able to rely upon one of the stricter conditions for processing. So if you're using, say, fingerprint scanners or iris recognition, that kind of stuff to enter parts of your building, what's your legal basis for that? If it's for health and safety purposes, you may well have a legal basis for that. But if it is just simply if using it, say, for time recording purposes to find out when staff enter and leave a building, for calculating how long they've worked, then that may be problematic. So these are issues which people hadn't really thought about, but actually when you go into the detail of the GDPR and the Data Protection Act are starting to create some issues. So one of the tools you can use here, again, to go back to accountability, is a data protection impact assessment to actually think about the issues of what you're doing and assess whether it's lawful and the steps you can do to carry out that activity in a lawful manner. And it's also a very good way of actually recording how you've decided what you're doing is lawful. It's a very useful tool. We may get some regulatory guidance in this. The Information Commissioner will be updating their Employment Practices Code of Practice at some point, and I suspect some of these issues may well be addressed in that, but at the moment we have no timescale for that coming in. And then the final point, just to mention on lawful processing, again on special category personal data, is that one of the requirements under the Data Protection Act 2018 is that for certain, when you're relying on certain legal bases, particularly the ones about processing the substantial public interest, that you have something called an appropriate policy document. And that's a document which sets out how you're complying with the data protection principles, how you're complying with the requirements in terms of data security and data retention. Now that may be stuff that you've got covered in a number of policy documents across your organisation, but the expectation seems to be that you'll have a single document that brings that together when you're relying on those conditions. So again, it may be something that you need to look at depending on your legal basis. Okay, electronic marketing. Again, questions we're getting around this. So a lot of organisations have carried out re-consenting exercises, particularly for email marketing. I'd say a lot of these probably weren't necessary, and I'll talk a bit more of that in the ePrivacy section. But if you've done that and you've said to people, we will only contact you if you agree to opt in to continue hearing from us, what happens if no one replies? Well, the difficult answer is you've told people you're not going to contact them, so you can't do it. So there's a challenge there as to how you deal with that, if you've had a decimated customer list because of that. There may be some creative stuff you can do. So, for example, the stricter rules around electronic marketing don't apply to doing telemarketing. So maybe you can re-engage people by doing a telemarketing campaign. you may be able to do a postal-based campaign. But it is a difficult issue, but there are potentially ways that you can get yourself out of some difficulty in that. On privacy notices, as we said, organisations now generally have updated the privacy notice and put them on their website. It's clear that people are taking very different approaches to the level of detail that are going into that. If you go to the Brodies website, you'll see what we've done in that and what we think is an appropriate level of detail. Some of the organisations have taken a very light touch in terms of what they're telling people. And the guidance that we have on transparency, which deals with all of this, doesn't really say to what extent you need to explain what you're doing with their data and the legal waste of that and how all that should be mapped together. But I think it'll be interesting to see how the regulators view that, and I think actually going to the Information Commissioner website, own website, and looking at their own privacy policy is quite instrumental in terms of seeing how they tackle that. So I think we will see that develop. People will continue to work on the privacy notices in terms of what they put into them. Other challenges around privacy notices, so if you have a large mobile workforce, you may have people who don't have access to email or the corporate network. How do you communicate your privacy notice to them? Some of our clients have been using things like town hall meetings to communicate and provide updates to that. It may be you can enclose a copy of your privacy notice with a payslip or something like that, using posters. There's lots of different ways. Just because people don't have a corporate email address doesn't mean to say that it's going to be impossible to provide your notice. So think about how you can be creative in that in terms of telling people what you're doing. And finally, on privacy notices, so we have a few clients who are multinationals who take or want to take what they've done in the EU and roll that out and say, well, let's use this privacy notice for all our employees across the world. And that's great, but remember that the data subject rights that we've spoken about already only apply to data subjects who are in the EU. So before you roll out your privacy notice to all your workforce across the world, consider whether you want to give those rights to individuals who don't have them under law. You may want to, and you may want to give them those rights, but you don't necessarily need to do it. And certainly some organisations may point that and said, actually, that's a good point. What we'll do is we'll take the transparency part of it, but we'll not necessarily give all these additional rights that we don't necessarily need to provide. And then finally, again, go back on things that people are doing behind the scenes in terms of preparation arrangements with third parties. So I think over the last few months, I've had far more conversations with clients on whether an organisation they're dealing with as a controller or a processor than I've had probably in the previous 5 or 6 years. Just because people are now paying far more attention to that. Historically, people would always just put in a controller to processor clause in their contract, but never actually stop and think whether that was the appropriate thing to do. But because of GDPR, because of the accountability requirements, it's far more important to understand what your role is. Are you a controller? Are you a processor? Are you a joint controller? What's your relationship with the other party? And actually trying to document that and understand it, because without doing that, you can't actually know what your obligations are under data protection law, and you can't know what you need to put in your contract. And quite often it's not straightforward. It's very difficult to actually reach a decision on that. Some arrangements are very complex. And finally, people asking, can processors charge for providing assistance? So under GDPR, there's a requirement that your contracts with a processor who's processing on your behalf contain certain obligations on the processor to provide assistance and cooperation. There's nothing to stop a processor from charging for that. They can charge on whatever basis they wish. It comes down to commercial negotiation. Yes, they have an obligation to do it, but as to how they're remunerated from that is up to you to agree with that party. So ultimately, one way or another, if you're dealing with a processor who's providing services to you, you're going to pay for that assistance. The question is whether it is rolled up in the overall charges you're paying, or whether it is actually in a transparent, broken down manner. And what's appropriate will really depend on the nature of the service you're getting, and perhaps also things like who's actually at fault, say for a data breach, or say a requirement for an audit. There are lots of different ways to cut that. Okay, so moving on to ePrivacy. So just a quick recap in the law here, because I think this is where a lot of the confusion came from in relation to some of the reconsenting exercises. But the requirements on electronic marketing have sat independent to data protection in 1998 for a long time. So the rules requiring prior consent to market have been around since 2003. And those regulations, privacy and electronic communications regulations, continued in force unchanged under GDPR. All that changed was that the test for valid consent became the GDPR test for consent, which is a tighter, more specific definition. But actually, if you looked at it, basically outlawed a lot of the stuff the Information Commissioner had already been saying was probably not acceptable anyway. So there is a requirement if you're doing electronic marketing, it's marketing by text message or by email, to have consent, but that doesn't apply in all situations. So if you're doing B2B marketing to another organisation, then generally speaking, you don't need consent for that. If the recipient is or the target is a sole trader or an English partnership, then the Information Commissioner's view is that they will be protected by the rules in the 2003 regulations, but for most B2B marketing, those rules won't apply. And similarly, we have something called the soft opt-in where, sorry.
Martin, sorry, would you mind using the microphone?
Yes, is it, I thought the, is it off? Is that better? Yeah. So the second part under the 2003 regulations is the soft opt-in, which is where if you have existing customers, you can market to them for similar goods and services where you collected their details previously. So again, if you've got customers and you've sold goods and services to them before, you don't need their consent to continue marketing to them. And so I think the interaction between these rules and GDPR and the requirements and consent is something that has led to a lot of confusion as to whether or not organisations needed to carry out these reconsenting exercises. Now, for those of you that have attended our previous updates on data protection law, you'll know that there are plans to update the rules on ePrivacy as well. We had a draft regulation published in January 2017. That is still under discussion. We don't yet have a finalised text for that. The original plan had been that it would come into force on the same date as GDPR in May this year. It is still being negotiated by the various EU institutions. But I think we expect it to be finalised at some point in the next 6 months or a year to come. What are the headlines from that? Well, firstly, soft opt-in, which I've spoken about, will remain, which is good news. If you use cookies on your website, as everyone does, then the rules on that are being simplified, which is good as well. So those banners we have at the moment, there should be a reduction in terms of those. And using things like data analytics, web audience monitoring, that won't be something you require to get consent for. Now that's at odds with the current guidance that we have from regulators and use of cookies. So we've got a slight conflict between where we know the law is likely to go and what the regulators are saying. But there remain some difficult issues, and that's why we don't yet have a finalised text. So so-called cookies walls, where you have to agree to cookies to access a website. There's a big tension between what the advertising industry would like to do and what privacy campaigners would like, and that is one of the core points of contention in the regulation. And then there's also talk about possibly extending some of the rules on limiting electronic marketing to apply to B2B marketing as well. It remains to be seen where we go in that. Okay, so that's all I want to say on GDPR. What else has been happening? Well, there's two recent cases I wanted to speak about. The first one is just from 2 weeks ago, at the start of June, and it involves Facebook and the use of Facebook fan pages. So these are pages on Facebook that organisations can have for people to follow their organisation, to interact with them. So a lot of you will work for organisations that have a Facebook fan page. And this was all to do with who was the data controller for using that page. And this ultimately went up to the European Court of Justice to ask who's the controller for that. Is it Facebook, who runs the network, who has access with the individuals that follow it, or is it the entity that's actually administrating that page? And what the European Court of Justice said is actually that both parties are joint data controllers. And that was a bit of a surprise, I think, to most people, because if you look at, say, a Facebook fan page, yes, the organisation that uses it has access to some of the analytics, but they have got no control over what cookies are deployed, what information is collected from the users, and what's done with that. But what the European Court of Justice says is, yes, you're joint controllers, but that doesn't mean that you have equal responsibility. But because the administrator has access to insights that come through that, because they have access to directing people to follow that page and interact with it, they have some responsibility there. So what that means is that using social media network pages like this are something that you want to cover in your privacy notice. I don't know how many of you cover that at the moment in your privacy notice, but following on from that, if you are a joint controller, you will need to explain in your privacy notice what information you collect through your Facebook pages, through your other social media presences as well, and how you use that information. And the thing had wider impact. We've not quite got to the bottom of how it's going to impact on things going forward, but it's fairly clear that the European Court of Justice, at least, is taking a fairly broad interpretation of what a joint controller is, perhaps broader than we thought before, whereas perhaps we might have thought that these parties might be arm's length controllers. Actually, what they're saying is you're a joint controller. So I think when you're engaging with other parties and you're reviewing whether or not you're a controller or a processor or a joint controller, it's important to have a look at this decision and the impact of that on how you classify your relationship. In the meantime, and I think we will get some guidance on this, but in the meantime, have a look at your privacy notice, make sure you're covering how you're using these pages, and also look at, I expect, the likes of Facebook will be updating terms of use to actually cover this, because they're going to have to change their conditions for using services like this. Things like custom audiences, Google Customer Match, if you're doing targeted advertising online. Again, I think the position that the networks are taking being a processor probably doesn't stack up under this decision, so it may well be that they review their position. The second case I wanted to speak about is actually what the very first comment I had when it started this morning on Morrison's supermarkets. So you may be familiar with the background. This was an individual who was an employee who had a grievance against Morrison's, and in spite of that, having gone through it, released the personnel file for 100,000 employees onto the internet. Now, he was caught fairly quickly and he was sentenced to jail for 8 years for doing that, but 5,000 of Morrison's employees brought a class action against Morrison's for claiming for compensation under data protection law. So we had a decision that started December on this, and what the court said is that Morrison's wasn't a controller in relation to what had happened, so they weren't directly responsible for the data breach because the individual had gone off and done this on their own. The individual was a controller for that. But nevertheless, the court said that Morrison's was vicariously liable for what this individual had done and therefore liable to the employees for compensation. Now that was a bit of a surprise because the first part of that made sense. I think if you have a rogue employee that does something, you can't be liable for that. But then go on to say, well, this vicarious liability seems to have a little bit of a tension between what the court has said on the one hand and vicarious liability, because if it's gone off in a frolic, how can you be vicariously liable for that? So that decision, I think, will be appealed. But meantime, I think what it does do is it highlights the importance of not just thinking about the external risk for cyber attacks, but also the insider threat. So rogue employees doing stuff with personal data within your organisation, because it clearly is a risk there. So thinking about things like access controls to documents, monitoring information that leaves your organisation, all that kind of stuff can help with the risk of this. Because if you have a sensitive file like that people have access to, it's very easy for someone to actually take it and share it and cause a huge amount of harm. So don't just think about the external risk, but also think about the insider risk as well. And with that, I will hand over to Grant to look at some more data security trends.
Thank you. Yeah, so what I wanted to do was to just highlight 3 recent cases involving organisations that have been fined for data protection breaches. Now, these are all pre-GDPR, but I think they are still absolutely valid for the new regime. The first one involving the Royal Mail Group, I think is just another warning. You may be aware there were previous decisions involving Flybe and Honda, who were fined for sending marketing communications to people who had previously opted out. The Royal Mail Group decision, I think, is just another reminder that if people have opted out, you have to be very, very careful about what you send them. So in the case of the Royal Mail Group, 300,000 people had opted out of marketing. They received an email communication, which the Royal Mail said, we have to send this because we have statutory obligations and this is about our service. I think it was a good argument, except that the email concern said price promotion, price drop for 3 months. And the ICO was not wearing the fact that that was a service email. It was clearly intended to encourage people to use the service by dropping a price. So you have to be very, very careful. The distinction between service emails, those that you have to send as part of a service, and marketing is quite blurred, but the ICO is taking a fairly hard line. Now, in that case, the fine was only £12,000. It's quite small, but, you know, post-GDPR, that fine may well go up. Second case I wanted to highlight is indeed a lot more troubling. So this was one involving the Crown Prosecution Service, and this involved 15 DVDs of interviews with victims of sexual abuse. So the police sent these DVDs to the CPS's Brighton office for evaluation as part of ongoing preparations for a trial. The DVDs were sent by DX. They arrived early in the morning and they were left at a part of the building that was not attended. And the 15 DVDs went missing and they've not yet been found. So, I mean, it is a very, very serious case, and the fine in that case, I think, was £325,000, which, given the maximum under the 1998 Act, was £500,000, shows how serious it was. I think, again, it's just a salutary lesson about making sure if you've got sensitive data, or indeed any personal data that you're sending, you need to actually think through the arrangements to make sure that it doesn't go missing. And in the case of this one, it's just the fact that it was delivered at a time and to a part of the building that was not actually attended, and stuff went missing. So again, bad things can happen. The final one, University of Greenwich. This is the first time a university has actually been fined, and this related to a microsite that had been set up in 2004 by an academic for a conference. And it had a lot of people's data on it. I think it was about 19,000 data records, and 3,500 of them contained, information that was sensitive. And the problem was that the site was never shut down. So it was used for an event in 2004. Because the academic had set it up, and it did sound as if it wasn't an official site that had been set up by the university, nobody shut it down. And in 2016, it was used as a point of entry for a cyber attack. And ultimately, the data was compromised, and the university got fined £125,000. I think the important bit here for me is, if you set things up, you've got to take them down when you no longer need them. So just the problem was that it was left. It was left and it was forgotten about. And as a result, it was off the radar of the university. So when the bad thing did happen, they were completely taken unawares. So you just need to make sure that as part of your processes, if you set one-off things up, or indeed something that you have used but you no longer use, you need to think about decommissioning it and taking it down. Otherwise, you leave yourself vulnerable. Those of you who come to these things regularly will know that we look at the data security trends information reported by the ICO. So this is for Q4 2017. The number of reported incidents had risen by 17%. And I think in part that might be just because people are becoming more and more aware of data security in the run-up to GDPR. It'll be very interesting to see how many incidents are reported after GDPR comes into force, because I think as staff become more aware of the responsibilities, there will be more reporting of things that perhaps previously were not reported. But I think what's interesting for me, and I say this every time we talk about it is the same things that account for the majority of the reports. So even though the regime may change and we're in a GDPR world, I'd rather suspect that the things that cause people to report to the ICO will not change. So the majority of incidents are around data posted or faxed to the wrong persons, loss or theft of paperwork, data sent by email to the wrong people, failure to redact data, and also failure to use BCC when emailing multiple recipients. Now, these are all things that can be stopped, but I think that organisations find them particularly difficult. But if I was thinking about all of the GDPR stuff, my belief is that whilst GDPR does raise a number of very difficult issues, some of which Martin has talked about, actually the big risk for the organisation, in my view, tends to come from poor data management practices. And these trend reports show the same thing quarter by quarter by quarter. Cyber incidents rose in Q4 2017-18. Be interesting, that was the first increase in a while. I don't know whether that's a spike. It'll be interesting to see whether in the next reported quarter's incidents, cyber continues to rise. Education sector reported a spike, so incidents up 32%. Again, I'm not sure whether that is just because figures vary from quarter to quarter. But if you are in the education sector, I think you're probably on a watch list, and similarly with charities as well. So things just to bear in mind. So just really to wrap up, what I wanted to do was just talk about the things that we expect to see probably the next time we come to do this talk as having happened. So the ICO is going to issue codes of practice under the 2018 Act. I mentioned earlier there was a responsibility on the ICO to do so, and they're going to issue codes in some very interesting areas. So there will be a code of practice on direct marketing. It'll be very interesting to see what the ICO is saying, and similarly in relation to data sharing. So look out for those. Follow us in the various ways that we promote what we do, because we will be telling you when these things are coming out. There will be a code of practice for age-appropriate design for websites and apps. So if you do things that are targeting children, you want to be aware of that. And there will also be a code for journalism as well. So, and the important thing is, because these are statutory codes, then actually the courts have to consider them. So if they are looking at the legislation and they are looking at whether or not people have complied with it, they have to take these codes into account. So they're not just like good practice recommendations. We expect, although the timescale for this has been more elastic than we expected, that there should be a final text for the ePrivacy regulation. And there's quite a number of important issues we'll hang off that. Max Schrems will continue, no doubt, to keep challenging everything. Schrems too, so there is, he is unhappy. Martin was saying he was unhappy about various things that have happened under GDPR, but there is an ongoing case going through Ireland, which has gone up to European Court, where he is challenging the use of EU model form clauses as a mechanism to export data outside the EEA. And now, if that challenge is successful, that will cause some shockwaves. One of the things that is interesting is the European Commission has not published a new formal model clause agreement for GDPR. And I suspect the reason for that is they're trying to understand which way the court is going to go on the current model form clauses contract before they republish. Existing model form clause agreements are still valid, but we'll have to watch this space to see what the European Court makes of the challenge. I don't expect that immediately, but it is something that we'll all be very, very closely monitoring. The other thing will be, of course, Brexit. The UK government has made it absolutely clear that it wants, as part of the deal when we leave the EU, for us to get an adequacy finding so that we join the list of whitelisted countries so that data can move freely between the EEA and the UK. But that's going to be a bit of a political discussion, so it'll be interesting to see what happens there. And of course, you know, we will expect to see enforcement actions against organisations that are breaching GDPR. It'll be very interesting again to see what the ICO is targeting, what the priorities are, and what the attitudes are. And not just actually the ICO, but also looking at what other regulators around Europe are doing, because the ICO, as I've explained, will have to act in a manner that is consistent. So there is actually a heck of a lot happening. You know, if you think that GDPR was a culmination and everything's going to go quiet, I think again. This is going to move quite quickly over the next 6 months or so. You can find out more information. We say a lot about what's happening in this space and through various channels. You know, please do follow us. But actually, in the couple of minutes we've got left, Martin and I will take any questions. This feels like a presidential communication.